Hello, this is Matt on the Moon Lambo channel, and immediately after this video, I'm going to go streak the quad. You're all invited to join me because Judge Torres has decided that Ripple's fair notice defense stands. Incredible news. I firmly believe that this is going to make settlement with the SEC and Ripple much more likely because the SEC, as I've been highlighting on this channel for some time, has a lot more at stake right now. And there's reason to believe that if this case is fully adjudicated, that they would lose. Now, to be clear at the outset of this video, this does not mean that the judge has affirmed that Ripple's fair notice defense is the winning idea. That's not what this is. The judge has affirmed, just decided, pick your damn word, I don't care. I'm elated at this moment, frankly. The judge has decided that Ripple's fair notice defense can be argued in the court of law. It's to be considered, period. This is basically the SEC's worst nightmare. I saw the news. Here's on your screen. This is where I first saw it from John Deaton's crypto law organization. Tweeted this out. This is where I first saw it. 1:23 p.m. today Central Standard Time, which is the time zone that I'm in, Central Standard Time. Judge Torres denies SEC motion to strike fair notice defense. Well, hallelujah. This is absolutely incredible. This is huge news. And I coincidentally put out a video literally yesterday where I noted that this ruling could be coming down potentially imminently. And you might think that, the words maybe and imminently or potentially imminently, like those words shouldn't go together. But it had to do with this idea that the judge, in this case Judge Torres, has to report to Congress twice a year per federal law on any motions pending that go past 6 months. And so, if the judge cares about that, in that case, it would make it imminent for her to decide whether or not this is going to be, the motion is going to be stricken or not. And so in this case, the judge struck the motion. Huge news. I can't emphasize that enough. This is absolutely gigantic. So what I did is I printed up this delightful, tasty little tidbit. You hear that? Some dead trees up in my hands right here. And I read the whole damn thing except for the background, which happened to be the first 4 pages. And I'm going to share with you the parts that I highlighted that I found to be the most very scrumptious. It's going to all good up on the palette. You guys are going to love this, seriously. Let's just celebrate this. But before going further, I do want to be clear, I do not have a legal or financial background of any kind. I'm not offering legal or financial advice, and you definitely should not buy or sell anything because of anything that I say or write. I'm just an enthusiast who enjoys making YouTube videos about crypto-related topics, but just as a hobby and just for fun. Take a look at this first. Please take a look at this. This is a tweet from attorney Jeremy Hogan from 4 hours ago. So to be clear, this tweet, he put it out all up on the Twitters before it was known that Judge Torres was ruling in favor of Ripple's fair notice defense. Before. 4 hours ago, folks. And by the way, for frame of reference, in case anyone's curious, it's currently 2:37 p.m. Central Standard Time as I recorded this. So I found out about this just a little over an hour ago. I quickly printed this thing up and read it and highlighted some interesting points. And I was like, I got to get the news out. Please spread the word, by the way. Whether it's my video or just tweet out or call you Ma, call you Paul, call you Grandpappy, call you Grandmappy. That's not a thing, but just call you Grandmappy because whatever. But here's what attorney Jeremy Hogan had to say. Dear Judge Torres, I know you've been working on the pending rules in the Ripple vs. SEC case this week. On behalf of myself and certain other interested parties, we'd really like to get those rulings today, if possible. Very truly, Jeremy Hogan. Do you see this? It's on your screen right now. Can you believe that? It's like, yeah, we'd like to get it today. And just a couple hours later, yup. And so John Deaton's crypto organization responded to that and just wrote, she heard you. And to which Jeremy Hogan responded, now I'm a little spooked, is the judge on Twitter. And so, what can I write? I just responded, I wrote, okay, fine, we do live in a simulation. I'm kidding, but laughy emojis. I'm elated by this. This is huge. Folks, again, can I emphasize, I know I said, I want to say it again. This really does, in my estimation, based on what I've come to understand from attorneys in the space, this makes settlement with Ripple way more likely. Actually, I'm not even going to say, let's just look at this right now. XRP is rocketing up. Here, let me go to a 24-hour chart. Look at this. Here's when the news broke. XRP was at 73 cents, went up to 77 cents. Now, to be clear, this is not because Ripple's controlling the price or anything like that. It's because the SEC is asserting that XRP is associated with Ripple specifically. So when we get news favorable in this context, of course it rockets up. So as awesome as this is, you freaking wait. You just wait until there's an actual settlement or full adjudication of this case in favor of Ripple. This is going to look like nothing. That's my suspicion anyway. So it's like either you have exposure before something like this happens or you don't. Now, this isn't to say that this is going to keep going up, and I'm not saying there wouldn't be some dramatic retrace. Crypto markets are crypto markets. But I'm just sharing with you, there's clear jubilation within the markets right now, this very moment I'm recording this. We'll see how high it goes, and I get it. It's, like I said, markets retrace. I expect that to happen too. We'll see how high it goes in the first place. But look at how people are responding. Wait till settlement. It's absolutely astonishing. So, let me get into this now. So, like I said, the first 4 pages is actually just background information. So let me jump right ahead to the analysis portion right here. I can scroll on down for those of you looking at the screen. Analysis, here we go. Legal standard under analysis here. Under Federal Rule of Civil Procedure 12F, a court may strike from a pleading any insufficient defense. Motions to strike an affirmative defense are disfavored and should generally not be granted. So pause. The judge in writing this is recognizing that typically, if a defendant's making an assertion and it's a defense, you typically let them make the defense. So it's already kind of like a high threshold, according to the judge here, for this to not be granted. So you really have to make a strong case that there's insufficient evidence for this defense to not even let it be argued. That's a high bar. So the judge is recognizing that and saying, no, they should get to argue it. Again, the judge is not saying that Ripple did not have fair notice. That's a different argument. The judge is saying that they should be allowed to argue in court that they didn't have fair notice, which still, again, a huge one. That's why I'm anticipating the likelihood of settlement, my gosh, through the roof at this point. Anyway, the next part, it's down here is where I want to highlight this bottom portion here. To succeed on a motion to strike an affirmative defense, the SEC must show that, number 1, there is no question of fact which might allow the defense to succeed. Number 2, there is no question of law which might allow the defense to succeed. Number 3, the plaintiff would be prejudiced by inclusion of the defense. Yeah, so again, burdens of proof of position not met, clearly. And then if you go down to this portion, under application, judge wrote the following. A fundamental principle in our legal system is that laws which regulate persons or entities must give fair notice of conduct that is forbidden or required. This clarity requirement is essential to the protections provided by the Due Process Clause of the Fifth Amendment and requires the invalidation of laws that are impermissibly vague. What the hell do you think's going on here? Impermissibly vague. Yeah, I think that pretty well sums up what the hell's going on with the SEC's approach to crypto. Impermissibly vague. Yes. 100% precise. Anyway, continues. The judge continues. Laws fail to comport with due process when they fail to provide a person of ordinary intelligence fair notice of what is prohibited, or when they are so standardless that they authorize or encourage seriously discriminatory enforcement. Gotta clap right there. Enjoy reading that right now. I'm gonna go a little bit lower here. It's the bottom of page 7. Yeah, here we go. Right here. After considering the SEC's arguments, the court holds that the SEC has not met its burden of showing that Ripple's fair notice defense should be stricken at this time. It feels so good, like coming out of my mouth, just rolling off my tongue. I'm like, ooh, that's very nice. I am very happy to be reporting this. I thought this was going to happen, but you never know for sure. I've been optimistic for a long, long time, but man, this is a big day, folks. It's hard to understate how important this is. It really is. You know me. I'm not this excited. Like I'm a happy-go-lucky type of guy. Like maybe that's not quite the right way to characterize my personality, but like, I'm happy and playful. Like, I have a happy temperament just by nature, so this is kind of how I am. I am extra happy today. I hope that's coming off in this video. Like, I'm having a good time here. This is a big freaking deal. So now we go down to page 8. Here we go. Yeah, it's starting right there. Ripple states that XRP's price bears no relation to Ripple's activities. It also asserts that it has not sold XRP as an investment, and that it has no relationship with the vast majority of XRP holders. At the very least, these facts, if true, would raise legal questions as to whether Ripple had fair notice that the term investment contract covered its distribution of XRP, and the court may need to consider these questions more deeply. Clap again. Oh man, it's a little stronger than a golf clap today, I'll tell you what. Folks, absolutely incredible. Absolutely freaking incredible. Like, so you guys are going to go streak the quad with me after this, right? Like, it's not just me, right? I don't want to be naked alone out there. Like, let's be all naked together. And then, here you go. It states also at the bottom here, the SEC has not met its burden of demonstrating that there are no questions of fact or law that might allow the defense to succeed. Judge gets it. That's why I said, look, it's more likely than not that justice will be done in this case. And even at this point, fine, it's not 100% guarantee. I'm not saying that. I've never said that. But I do believe in most cases within the United States judicial system, more likely than not, more typically than not, justice is done. You know? And so here, you still think too, and this is a fun stat for those of you that are unaware of this, like 95% of legal actions brought against any person or entity, 95% end up being settled, actually, instead of going to court. 95%. Is this going to be the outlier? Well, maybe, because Ripple, they got the cojones and the war chest to make this happen, so maybe. But the facts and circumstances are so against the SEC. And understand, the SEC, if this goes to court and the SEC loses, to be clear again, they are going to lose so much power because this is the roadmap for success for any other crypto-related company that has a coin associated with them. This is the roadmap for success. And so it's going to set precedent if fully adjudicated. I'd be very surprised if this thing goes to court. After this, I'd be surprised. It could happen, but I would be very surprised at this point. Unless there's some sort of bombshell that happens after this that's very negative for Ripple, I'd be very surprised if this goes to court. And then to wrap up the statement from the judge here wrote the following. Judge Torres. The SEC has not shown that it will suffer undue prejudice as a result of the continuation of Ripple's fair notice defense. An increase in the time, expense, and complexity of a trial may constitute sufficient prejudice to warrant granting a plaintiff's motion to strike. However, a sufficiently pleaded defense should always be allowed if timely filed, even if it will prejudice the SEC by expanding the scope of litigation. The SEC does not contend that Ripple's affirmative defense is untimely, and the court shall not conclude at this early stage of the case that Ripple's defense is invalid. And here's the money sentence right here. Listen up, folks. Accordingly, the SEC's motion to strike Ripple's fair notice affirmative defense is denied. Denied, bitches. I'll tell you what. I call these attorneys at the SEC asshats frequently, and they are. But let me be a little bit more verbose at this moment. They are baby back bitches. I'm not a financial advisor. You should not buy or sell anything because of anything that I say or write. That would be a very, very, very bad idea. Until next time, to the moon, Lambo, bitches.